Hi, Bill Henshaw here again. This is kind of a quasi-update on the Oakland case, but it relates to the recent denial of the writ of habeas corpus, which many of you that have seen my recent videos know about this. And the judge did this in one page, and it was an unopposed writ. It was a non-statutory federal writ that got converted somehow to a state writ. And the main case they rely on here is called People v. Madsen, 52 Cal 2nd, US 177, I believe it's the citation. And you can get a complimentary version of what I'm going to read you here with my annotations and of the entire case if you want to take a look at it. And you read this, this doesn't leave any doubt about what this system is all about. And I think it's why the judge did what he did here. He finally realized he had someone who's going to take the time to read cases. That's exactly what I do, and I encourage you to do it. And when I read decisions, especially from the 9-0 farts, I read the whole thing. The majority opinion, the dissent, if any, and often there is, especially in 5-4 cases, and footnotes. Sometimes most valuable stuff you see comes out of the footnotes, which gives you an indication with the internal memos that were going back and forth what the justices were discussing on how to decide the case. Very important to do that. Read the whole damn thing. And, not many people do it, but that's what I do, and it's what you should do. And the judge knew I was going to do it here. And he knew I was going to see these excerpts from Matson. And it gives the whole game away with habeas corpus. Listen to this. Says, quote, "We have concluded that the right to counsel does not include an absolute right to services of the character and capacity indicated. That the accused should have appointed counsel to defend an indigent and require that in so doing the attorney surrender any of his substantial prerogatives traditionally or by statute attached to his office. That a defendant for whom counsel is appointed should not be permitted to have counsel and to actively participate in the conduct of his case unless the court in its discretion determines that the circumstances of the case cause injustice will thereby be served and that the orderly and expeditious handling of the case will not be interrupted." Okay, it goes on, and it says that under the circumstances of this case, there was no error in refusing to appoint counsel to act in a subservient capacity, and that for the reasons aforesaid and hereafter developed, the judgment of conviction should be affirmed. My annotations here, and you'll get this. Send me an email at youwinningcourt@gmail.com. I'll get you what I'm reading and the entire Matson case. What do I say here? Wrong-o. Attorney-client relationship is, in fact, in the final analysis, principal and agent. We're the principals. We tell these bastards what to do. Can't be in any other way. The simple proof is that most, if not all, of the victims of the justice system, who are not artificial corporate entities, are also lawful de jure jus sanguinis state citizens, aka beneficiaries of the trust known as the United States, whose ancestors ordained this Constitution and all government to secure the blessings of liberty to ourselves and our posterity. And that's the way that is. I mean, and therefore we have a right to do both. They're dead wrong here. If you're a 14th Amendment citizen, you're in trouble. We can do both and have the right to do both. And given my recent interview with defense counsel in the Oakland case, we're going to be doing both. This guy hasn't got a clue. And he's going to put on a meaningful and substantive defense in this case? Not how it's going to work. Case goes on. Defendant's insistence upon representing himself and at the same time being afforded assistance of counsel. Defendant appeared in Superior Court for arraignment. Proceedings on this end of subsequent days to the time of trial, quoted and summarized in margin, disclosed the following situation. Defendant repeatedly refused to accept appointment of counsel to represent him and insisted upon representing himself. He stated, and the court refused appointment of counsel to aid the defendant in filing papers, preparing subpoenas, and obtaining documents. And that's reversible error there and then. The court, on its own motion, gave defendant much legal advice. It doesn't say what the hell it was, But the point is, when you get into an arraignment, understand this, people. That's an important time, and they don't tell you. You never see this on Law and Order. You go in there, how do you plead? Well, if you've gotten my document packets at uwinnincourt@gmail.com, you're already going to have in there a demand for a bill of particulars and an objection to entry of plea. A highly jurisdictional act. If you enter a plea, you give the court jurisdiction in the only way it can get it. That's how important that is. And they don't tell you that. What your attorney should be telling you is what I just told you: don't enter any plea until they enter the bill of particulars and you know what the jurisdiction is, the rules of the game, identity of the elements of the crime, the identity of your injured party for purposes of confrontation and cross-examination. Entry of a plea virtually waives everything that we've been discussing here. And I've got the U.S. Supreme Court, as I always do on this subject case, is U.S. v. Crane, C-R-A-I-N, 162 U.S. 625, saying exactly what I'm telling you here. But they don't want you to know that. They want to enter a plea, and they think they can do it because in California we have Penal Code Section 1024, been on the books 150 years, but there are no case law decisions. Can anyone explain to me why that is? I don't get it. In 150 years, this is before the 14th War Amendment, and I don't think it would have been constitutional even then, but certainly it's based now in whole or in part on Section 4 of the 14th War Amendment that no one ever reads. They all love the part about due process of law and equal protection. You get to Article 4, what does it say? The validity of the public debt of the United States authorized by law shall not be questioned. What that means is you become hypothecators of goods or stipulators in the Admiralty, which is the jurisdiction that they run. That's why they can't answer a bill of particulars, because they tell you what the jurisdiction is. Admiralty, see you later. State courts can't exercise that jurisdiction. Ends the case there and then. That's what's going on. But since you volunteered into their, what I call citizenship, he who accepts the benefit must bear the burden. Did you ever hear that in your days in the all-high mandatory public school system? I sure as hell never did. If I had heard that as early as 8th grade, my life would have been different over a half a century ago. They don't want you to know any of it. And that's why they think they have jurisdiction over you and complete power. It doesn't matter what they do, what they don't do. They have complete, quote-unquote, judicial immunity, which is a great trick in the legislative tribunal, by the way. So, my gosh, it just gets worse. Goes on, as has been stated, despite the Constitution, Article 1, Section 13, provisions for the defendant, has the right to appear and defend in person and with counsel. That settles it for me. Defendant is not entitled to have his case presented in court by himself and by counsel acting at the same time or alternating at defendant's pleasure. And they give some case citations for that. Bravo! They haven't taught us a damn thing in their mandatory public school system. How are you going to know what your rights are, let alone be able to put on a meaningful and substantive defense in court? That's the job defense counsel took on when they went to law school. They got that license to practice law, and they swore an oath to be bound by this Constitution and the laws enacted in pursuance thereof. Why the hell aren't they doing it? Damn. Goes on. A fundamental reason for according the accused the right to counsel is that without the aid of an attorney and protections which the law affords, I'd love to know what those are, would often avail defendant little if it cannot be assumed he's sufficiently articulate and adequately conversant with his constitutional and legal rights. And that's true. No education in the public school system. And his procedural duties to protect himself throughout the course of the criminal proceedings. So all of that's true. And by the way, that has nothing to do with are we competent or not. Two different things entirely. And they make a big deal that they're doing in the Oakland case. We're on round 5 with competence with oral motions, which they have no authority to rule on. There's been no expert witness testimony as to my friend's quote-unquote competence or lack thereof. And note here in my South Carolina case, I had 2 1-hour sessions with this shrink back there in order to determine whether I was competent, which they knew in the first 30 seconds of my first appearance. Nothing like that here. They couldn't care less whether you're competent or not. They're either going to appoint counsel to shut you up, or they're not going to answer any of your pleadings and consider them frivolous and convict you anyway. That's what this damn system does. So it goes on. Oh, this is a beaut here. Common knowledge of judges and attorneys, and to some extent the transcript in the case at bar, points out that suggests that there are some persons who, although not members of the bar, undertake to act as their own attorney. Pro se. That's not what we're doing. To present their cause or defense, and in so acting, do not appear to be bound by the to maintain the respect due the courts of justice and judicial officers. And or to employ for the purposes of maintaining the causes such means only as are consistent with the truth, and never to seek to mislead the judge. But what the hell? I go in there, I have no respect for them at all. I mean, they're committing acts of treason, they're violating the oath of office. Why in the world would they think we're supposed to respect that when they're in their damn courtrooms? It's just way off mark. Goes on, what I call the coup de grace here. It's a general rule that a defendant who is represented by an attorney of record will not be personally recognized by the court in the conduct of his case. Okay, applies to the filing of pro se documents on appeal. And it goes on to say, because of the undesirability of fraudulently or fruitlessly aiding the burdens of this court with time-consuming task of reading pro se documents which are not properly before us, whatever the hell that means. And this is code, by the way. What it really means is they don't want to read documents where they don't have a clue what the law is, and they're too embarrassed to admit it. That's the real what they're saying here. And if they be read, of consequently enlarging the opinion by recounting and discussion of contentions made in propria persona, such documents filed in this appeal by the defendant should be stricken from the record. And they say summarily stricken without you even having a chance to be heard in court as to why they're doing it. Because they're getting rid of all of our issues under the first 6 articles that defeat the jurisdiction of the trial court. That's why they want to cram an attorney down your throat. They couldn't get away with that with me in South Carolina, and they didn't, and that's why they eventually had to give up. Because they knew, I was tried, by the way, with practicing law without a license. That was a felony there. They knew if I go to trial, not only I win the case, I'm going to break the state bar monopoly. And that's what we may have a great chance to do in your case, too. It's the same thing, and for the same reason. We have no right to an attorney, and yet, if we don't have an attorney, as I said in earlier videos, the Supreme Court says no counsel, no jail. That's the Argersinger rule. Argersinger v. Hammond. Where are they going to go with that? And they didn't make any limitations on that, by the way, the Supreme Court, when they said that. No counsel, no jail. And we have no counsel, and you're not going to have one if you have especially a public pretender. But even a defense counsel in those jurisdictions that provide for private attorneys, quote unquote, to take your case, just like I have a good old Steve shit-ass Shaman in my South Carolina case, the guy did nothing. And he will pay for it sooner or later. Trust me on that one. But attorneys aren't your friends. Don't ever be misled about that. So this is a key case, and send me an email at youwinningcourt@gmail.com. I'll get you the excerpts in this and the entire case. You can read it for yourself and make your own decisions. That said, be sure to like my videos, subscribe, and send emails, and we'll catch up and communicate more later. We'll have an update on this Oakland case the next time we do videos. Thank you.